He had more arguments to make. I don't, you want to wait?
No, I'm just wondering, we're about to go into the administrative law board hearings.
We're going to approve the resolution for Mr. Stapleton that just left.
Okay,
And we were hoping he was going to be here for this,
okay.
but I think that rig downtown is kind of holding up traffic a little bit. So we can give it a couple of minutes and wait for him, or just proceed with business. It's up to you guys.
For the record, I want to say that they stopped me on my way out the door to go to lunch today, and she wanted to explain to me that there was a gate and stuff, but I want to make sure it's on the record that she told me there was a gate, and that when code compliance went out there, that they went around it.
Okay.
So,
Have you read the resolution?
Yes,
You did?
yes.
How'd you get that resolution?
He was here before you was here.
But I had a couple issues with it.
You already read it and amended it.
I'm reading it, so I just need a minute to finish reading it, if that's okay. So we're going to call the meeting back to order. It's 2:10. We have a revised resolution before us to uphold the appellate's appeal.
There's one correction I'd like to make.
Okay.
Under on the second page, after the list of the bullet list there on evidence, first sentence says, of these violations, only the excess canopy, fencing, and posting standards were identified. Posting standards actually weren't identified, so it's strike and posting, so it would be excess canopy and fencing were identified. Just cross out posting.
On both sentences.
Yeah, because
Oh, yes.
Well, actually, that was listed as one of your, on your list.
It was on our list, but it was not one of the things that was on the...
No, I understand, but I mean, we shouldn't cross that out of your bullet list.
Not the,
Not the
I
bullet.
think it's the posting deficiencies in the second sentence under the bullets. Is that what
Right.
you're referring to, Commissioner Webster?
Oh, yes.
Well, the denial of the registration did identify 6 violations, and those are properly
Right,
listed.
that was one of the bullet list is correct.
The bullet list
The
is
two
correct.
references to posting in the
sentences below.
sentences. So strike the posting deficiencies.
Right, on the 2 sentences that follow the bullet points.
Yes.
So it'll be, as corrected, the fencing deficiencies and removed, so deficiencies is singular.
Okay, the other small issue I have is up at the top of the page there under evidence. The third sentence says there was a discrepancy between the 2 measurements, yet only the smaller amount of excess cultivation of 240 square feet was provided directly to the registrar's representative. I think it's a fair inference that the discrepancy identified by code may well have been provided verbally, because it does show up on the inspection report, but it was not provided in writing. And the only thing that was provided in writing via the email was the 240. So I would suggest that we put the words in writing after the word provided.
That's good.
Will provided in writing, okay.
And with those, I'm fine with the revised resolution.
Okay. So would somebody like to move to, or maybe should we have him read this first? Recommendation?
Yeah, if you want to read the recommendation.
All right, I recommend that the Planning Commission pass a motion to approve Resolution 2017-003, approving or granting the appeal of Greg Stapleton, Appeal 2016-1129, appealing the denial of registration 2016-427 as amended.
So moved.
I'll second.
Okay, all in favor?
Aye.
Opposed? Motion carries 5-0.
For the benefit of the appellant, this is not automatically grant. The issuance of the permit is complete, the review process. I believe the background review of the sheriff's office is not there. So when the status is complete, then we will complete our review of the application.
Also, later on, we, as the sitting of the, whatever the other board we are,
Administrative hearing.
has one of his, I didn't want you to think, him to think that we were done.
Yeah,
Okay.
on that, so were there, like, what are the things that are, that were held out, as far as like the denials that, I mean, is there anything left? I mean, as far as like that was like being said?
You know, Miss,
Why don't you get together with Scott
Okay.
and
Yep.
see what else.
Sorry, I probably don't even know the question I'm trying to ask.
okay.
But stick around for your later, there's another issue.
We're doing that right now, or?
Okay.
We're good. So there's no study sessions. So we're going to go to public comment for the planning commissioners. And does anybody have anything to say that's, the public can address the planning commission now on any issues that are not on the agenda? No? Okay, well then we're going to adjourn the planning commission meeting, and we are going to re-adjourn as the administrative hearing board. The first item on the agenda is 2016009 Rodriguez appeal, and I think we're going to go to you, Sabrina.
Hello again, I'm Sabrina Cable with Code Enforcement. I'm representing all matters today. If I may address items 1 and 2, the appeals were both withdrawn this morning by the appellant's attorney.
So they're going to be taken off the agenda.
Okay.
Wow.
That brings us to item number 3. It says here 2016-005, but that was changed on your paperwork. You'll find it's 2017-002. Appeal of Greg Stapleton's administrative citation issued due to the denial of his cannabis cultivation registration number 2016-427. As the Planning Commission has just granted his appeal, we would like to rescind our citation. If there's no denial, there's no reason for us to issue a citation, and we withdraw our citation.
Yeah, the basis for the citation was the issuance of the denial. And so he was growing without a pending registration. It was therefore a per se nuisance. Now that the denial has been appealed, there's no basis for the citation.
Okay. Did you get that?
Loud and clear.
All right. So we can move on to the next one, right?
Yes.
Unless you have something to say.
May I approach all you guys and shake hands?
No, but you can tell us at the mic how.
Thank you guys very much, Ron.
Thank you.
Thank you guys.
Have a great day.
That brings us to item number 4, 2017-001. Weiss amends appeal of his administrative citation issued due to the denial of his medical cannabis registration, application number 2016-124. On August 5th, 2016, the Planning Department denied his registration. You'll find a copy of the denial letter attached as Exhibit 1. On September 8th, 2016, the Planning Commission denied his appeal to overturn the denial. And on October 25th, 2016, the Board of Supervisors denied his appeal to overturn the Planning Commission's decision. On November 3rd, 2016, he was issued a notice of violation order to abate an administrative citation for unregistered cannabis cultivation. He was ordered to cease and abate. He was given 10 days to contact co-compliance with evidence of abatement. And on November 9th, he attempted to email co-compliance to inquire about what he needed to submit, but the email unfortunately went to a junk mail folder, which was not discovered until November 21st. After that, we received contact from Mr. Amin's attorney on November 23rd, appealing the citation as well as offering evidence of abatement. He stated that the abatement was complete on or about November 13th, which co-compliance accepted as true, and advised Mr. Stanley, Mr. Amin's attorney, that no fines would be assessed and the case would be closed. However, Mr. Stanley chose to pursue an appeal, I believe, to exhaust the administrative remedies in case he wanted to take it to the Superior Court. I'm unsure on the details on that. We told him we were going to close the case, but he wished to go ahead anyway.
I'm Ethan Turner. I'm a Deputy County Counsel. I represent code with respect to marijuana-related issues. I spoke on several occasions to Mr. Stanley, the attorney for the appellant. He is not here today. I explained to him that if he was going to take a writ on the planning's decision, he'd already exhausted administrative remedies. Apparently, he felt as though he needed to do this as well. He has not shown up, and I don't see any grounds in the appeal letter that he did provide to you guys that would give any basis for overturning planning or code's decision to issue a notice of violation, because he was denied his registration, continued to cultivate for a short period thereafter, and then voluntarily abated. So it seems that the issuance of the notice of violation was made correctly on the determination that there was cultivation occurring in violation of the urgency ordinance, but no fines issued because he voluntarily abated before his the time period ran that was required of him. So I would recommend that the board uphold the notice of violation, because Sabrina correctly determined that he was cultivating after his denial had been sent out by planning.
Only one question I have is on the case field report, it indicates that the notice was sent out on the 4th, which is...
Let me refer to that. I think I know what you're talking about.
I mean, I don't see where it makes any difference here.
It was put in on the 4th. If you'll look, I highlighted the wrong thing. There's a note made by Amanda Menchaca, and it was put in on the 4th. However, if you look, it says 11/03/16, mailed 2 copies.
Okay, great. So you are asking us to, deny the appeal, but there's no penalties?
No
involved?
consequences, no. Case is closed as far as we're concerned.
Is there any public comment on this? Okay. Seeing none, I'll bring it back to the commission to... Okay. I'm looking and I'll see him. Is there anybody here to represent Mr. Amin?
We haven't seen them all morning, so.
Okay.
Did you say Mr. Stanley represented him?
Yes, Mr. Stanley is his attorney.
Was it Ashley Margenquast?
That was for
Letter?
Mr. Rodriguez, I believe.
Ah, all right. Wait.
I have a couple of questions about the draft resolution.
Oh, yes, okay.
Under paragraph 3, It says, evidence, a notice of violation, order to abate an administrative citation was issued based on the fact that cultivation continued on the proposed registration site after the date of the planning department's denial of appellant's application. What information do we have that cultivation continued after the date of the denial of the application, other than the fact that his lawyer admitted in a later letter that abatement was completed on or about November 13?
That's the evidence that we have.
But this evidence is speaking to the reason why the notice was issued, and that letter didn't come in until afterwards.
Certainly, and that's a good question. Well, the determination was based on the fact that Mr. Amin applied for a marijuana cultivation site, declared under penalty of perjury that he was beginning to cultivate marijuana prior to May 10th, and we had just assumed, basically, that he continued to grow marijuana as he said he would on his registration application, according to the plot plan he submitted. And so we just believed him when he told us he planned to grow marijuana. And much of the application is filled out under penalty of perjury, so we had really no reason to doubt that he carried through with his plan to grow marijuana throughout the season. And since the denial occurred prior to what would be expected to be a harvest date, then it seemed fair to assume that, according to what he said, he was growing marijuana. And because, what was the date of his denial?
Okay, I understand that if you were talking about the planning department's denial on August 5.
Correct.
But we're talking about the issuance of the date of the notice of violation, and that's November 3rd. And I'm not convinced that that assumption is necessarily correct in the absence of other information to support it. And I don't know why that phrase is necessary for this resolution. Because what you're evidencing is simply the statement that you issued the notice on November 3rd. No question about that.
Mm-hmm.
Doesn't matter why you issued it for that purpose, whether there was evidence that he continued to cultivate or not. So I would be more comfortable with this resolution if that phrase, based on the fact that, and continuing through the rest of that sentence, wasn't there, because if anybody asks me, how do I know that, I can't point to anything in the file.
Well, and also, I share the concern in that on November 3rd, how many plants are still being grown for cultivation in Calaveras County? I don't know if we have any way of knowing that, but I would think that everything had either been harvested or abandoned by then.
At least the outside grows. The outside grows.
Yeah, that's true.
Yeah, code enforcement officers, as believe me, we've discussed this issue. It's of grave concern to us as well. And code enforcement officers, as they continue to do their inspections, have found that it is a common practice throughout the county to engage in year-round cultivation. Often starting clones or babies, or at the very least, keeping mother plants alive throughout the entire year. So anytime there's a mixed light cultivation operation or an indoor cultivation, we feel that it is safe to assume that cultivation is happening year-round. When if it's a strictly outdoor cultivation operation, then November 3rd, harvest probably has occurred, and unless there's plants indoors or in a greenhouse or something where they should have applied as a mixed light operation, then there would be no cultivation happening.
So, and this, I forget now, did this have any indoor or mixed light?
I believe it was a mixed light application. I don't have his application in front of me.
I don't have his application either, just his denial, but they did say on the 13th, the plants were taken down, so there were still plants growing after November 3rd, admittedly by the appellant's attorney.
Okay, well, I've said all I have to say on that point. I have another one, though, on paragraph 4. Seems to me the point you're trying to make is simply that the abatement took place on or about November 13th, 2016. That's the finding. And so I would strike everything that precedes the word abatement, and then the evidence to support that finding should be something like, Mr. Amon's counsel represented by letter of November 22, 2016, that the condition stated in the notice of violation was abated on or about November 13, 2016. That's your evidence. And the statement code compliance staff believes, et cetera, does not support the statement that you're trying to support. So that would be my suggestions on the resolution. I don't have any problem denying the appeal, because I think it should be denied. But I think the resolution ought to be corrected.
So Kelly, give me the exact numbers and lines that you're proposing to remove.
Okay. Under paragraph 3, under the evidence paragraph, first sentence, remove the phrase, based on the fact that cultivation continued on the proposed registration site after the date of the planning department's denial of appellant's application. And then in paragraph 4, strike the phrase, Wise Amen presented evidence to code compliance staff that, and change it to, the remainder to read, abatement took place on or about November 13, 2016, because that's what the council's letter says. And then under evidence, strike what's there and state simply that Mr. Amon's counsel represented by letter of November 22, 2016, that the condition stated in the notice of violation was abated on or about November 13, 2016. And I think that cleans it up.
And the other commissioners in agreement?
I am.
Yes, I'm agreeing with you.
Can we get a motion?
I would move to approve the resolution as amended.
I'll second. Go ahead.
Okay, all in favor, say aye.
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 Opposed? Okay, motion carries.
That's all we've got.
Does anybody have any public comments they would like to make? Okay, thank you for being here today. We appreciate it. We are adjourned.
Wow.